Ladies and gentlemen, welcome to this lecture on the ninth chapter of the book Law and Self-Regulation, Legal and Business Perspectives. When we were discussing the contents of chapter 5, which was about intellectual property, we included in that lecture a quote by one of these great guru thinkers, in this case Mr. Peter Drucker, and he stated that actually the two most important things in business are innovation and marketing. Innovation we will not specifically discuss today, that was chapter 5, but marketing indeed is the topic of today's lecture. And this lecture is a pretty extensive one in the sense that there are an enormous amount of topics discussed in chapter 9. For one reason or another, that is unavoidable because marketing is subject to many types of regulation, and that makes linking marketing and law, and the perspective of this course, how can we link law and business? This makes linking marketing and law a rather complicated task. So the challenge for specifically today is how can we keep it concise, simple and understandable, because in first instance the audience are business students and business managers. Well, let's try to take up the challenge and make a start with dealing with chapter 9. If we look at the learning objectives, we will find the words strategic and operational planning. That will be applied to marketing because we will look at it from a marketing strategy perspective and from an operational perspective, the operational perspective being the marketing mix. One of the reasons for the endless complexity of linking marketing and regulation is in the fact that in the focus of this course we focus on the EMEA, and that means that we will look into the strategic and marketing mix dimensions of marketing within the context of a manager having to manage marketing in the EMEA territory. That is fairly complicated, I'm sure you will immediately understand. We now start actually at the end of the chapter. At the end of the chapter you will find two conceptual frameworks which I'm presenting to you now because they illustrate what the perspective is. The first table on top illustrates marketing strategy elements, targets, competitive advantage, positioning, and a rough description, a general description of the marketing mix. We link that to what can happen to a company with respect to the developments which take place in the external environment. So by linking these, by first mapping the developments, and by subsequently linking these to the elements of a marketing strategy, you conceptualize ideas, options for what you can do. We apply the same in the second table, where we talk about the marketing mix, and we take a very simple approach with 4 P's, and we take the same approach vertically by identifying categories of developments, actions, which could take place in the external environment, which could affect the elements, the 4 P's of the marketing mix. Now let's bring in this EMEA perspective and let's look at it from a marketing and a legal perspective. When you go into the international marketing books, one of the strategies, which is generally described very extensively, is the company's choice between standardizing or localizing marketing. That is generally considered from a cultural perspective. Why is the question interesting? It is interesting because standardization can save cost, and localization is interesting because it allows for a better tailoring of a company's offering to the specific needs in the market, but it comes with cost. That's the business perspective. From a marketing perspective, looking at the EMEA territory. If we move on to the legal perspective, then having to manage such an extensive territory as the EMEA means for a lawyer in the company that it is pretty complicated for him to advise and ensure that the company is compliant, because we simply know that regulation is a national thing, can be a supranational thing, and there are also, of course, international arrangements which regulate products and other marketing elements. So the legal perspective is specifically on how to ensure compliance, taking into account the multitude, remember the learning objectives, the multitude of regulatory environments. Now, back to marketing again. We've outlined the perspective, and now we take a bit of a deep dive into the functional area of a company, which is referred to as marketing. The first question which pops up is, if we link marketing and regulation, what do we see? Well, actually a very simple conclusion, and that simple conclusion is that marketing is extensively regulated. What are reasons for this extensive regulation of marketing? First of all, marketing typically interacts with weaker parties, specifically, of course, when we talk about consumers, slightly less when we consider business-to-business marketing, but we know that the European Union and many other legal systems protect weaker parties. So this interaction must be regulated in order to protect weaker parties. Marketing is typically about being better than the competitor. It involves competition, but if companies would be able to compete as they want, they would be able to reduce the economic benefits of competition, and that is that competition drives prices down. So companies may be tempted to agree among them on prices, and that typically creates what in law is called, and also in economics, a cartel. Companies cooperate in price setting. That is prohibited under competition laws. Then the last element is that marketing's actions are visible in society. People see advertising, people see products, people read about accidents, people read about marketing practices. So that may trigger prosecution by the state for behavior which is considered unacceptable in a jurisdiction. And due to the internet and all other kinds of media which scrutinize companies' behavior, marketing actions being visible in society may trigger negative publicity. And then we have another issue which not by definition needs to be a problem, but the fact is that technology develops extremely fast. New technologies become available to companies for use in marketing, and we know that legislation develops slowly, so companies may face the challenge of what to do when a certain area, and we're talking now about the opportunities which technology offers, when a certain area is not regulated. How should we behave when the law does not give us guidelines thereto? Now, if we look at it from a risk management perspective, then the two main tools for companies to manage the risk related to regulation and marketing are, of course, contracts. Contracts can be used to shift risks. And secondly, internally, compliance. Make sure that you are in all your marketing activities compliant with the rules and regulations which cover marketing. But it's easily said and not very easily done in practice, especially not in an international business setting. So for you, if I may address you in this way, you as a manager, the challenges come down to a few simple words. Who will in the company ensure compliance? How will it be done? And what are the costs involved? These last three are the typical decisions a manager must make in order to be sure that the company complies to all the rules and regulations which apply to it. In order to understand the link between the two disciplines, we need some context. We need some understanding of what the situation within a company is and an understanding what the situation outside of a company is. When we look at the internal context, we can identify marketing managers who are responsible for a company's marketing, and we have lawyers. Marketing managers tend to be, to a certain extent, and sometimes too excessive, risk prone. They are under pressure, they must meet objectives, which may be even linked to a yearly bonus, so they will be inclined to try and see how far they can go. On the other hand, lawyers or compliance managers tend to be more risk averse. They are aware of the risks which marketing activities may run, and they will try to convince the marketing people to be very prudent or not to take the risk, or they will advise on what to do to mitigate or completely avoid the risk. Legal and compliance managers generally do not get a bonus. This leads to internally a conflict, an eternal conflict between marketing driving things forwards, taking risk, and legal driving things backwards in order to prevent the company from running risk of claims or prosecution. Now we should realize that what we just discussed, that marketing is externally visible. If we draw this in the following way, marketing and legal reconcile, this leads to a marketing mix which is brought onto the market and which is offered to target groups. In doing so, the marketing department may involve services providers like an advertising agency, a web developer, a market research company, etc. So the first notion is there are contracts involved. The second notion is that this offering, these 4 Ps, are visible externally. So it is offered to customers who react to it, who may not be satisfied with it. It is visible to competitors who may react to your advertising claims. And in doing so, in moving into the market, the marketeer should be aware, and legal knows, that rules apply to the 4 Ps. And this is then a simple list. The marketing manager must take into account legislation. Advertising is generally self-regulated by advertising codes. Companies have stakeholders who perceive what the company is doing in the market and may react to it. Society expects a certain behavior. Think about sustainability, think about non-polluting, think about respecting human rights. These societal expectations are met in the offering the 4 Ps in the market or not. Companies can relate, refer, consult, soft law, which can be considered as an indication of societal expectations, and in many a market the legislator has appointed supervisory authorities who overview whether a company stays within the limits of the law and who generally have the authority to impose a penalty on a company. Now this is the complicated working field, the context of marketing in combination with the context of legal in the setting of a company. Now we can extend on what we just discussed and take a more detailed look at planning at 2 levels, corporate and marketing, and use this to identify the regulatory dimensions. If we have them, we can use them to find more details, the details which a marketing manager needs in order to discuss what he is doing properly with the legal department, and it also identifies the areas of law which are of most relevant to lawyers when advising marketing managers. Take a deep breath. Here we go, and we'll try to do it concisely. A company has objectives, which we call corporate objectives. They are generally financial objectives and sometimes also reputational. How do we want to be seen by the market and by other stakeholders? When we talk about the strategies which the company develops, the corporate strategies, those generally entail the choice of markets and the choice of new markets. So we refer to this as new product markets, NPM, and it will include choices with respect to new products which the company wants to bring on the market. We refer to that as a new product development process. Now, these issues are governed by corporate law and corporate governance that we will not look into in more detail in this lecture. However, the marketing dimensions, that is what we focus on, and we know that in the context of new product development, we need to consider intellectual property rights and how to manage these. There is one element that requires specific attention from a legal perspective, and that is the question of entering a new market. Basically, the decision to enter a new market is what we call a market entry decision. There are different modes of entering a new market. A company can set up a subsidiary in the new market. That, and then I refer you back to chapter 7, requires the choice for a legal form of the business. But a company may also use contractual agreements to get its products sold in a new market. And we listed here 3. A company may involve a commercial agent who, on behalf of the company, contacts potential buyers in his market and actually mediates between the company and the potential buyer in his market, whereby the ultimate goal is that the potential buyer in the new market contracts with the company, not with the agent. A distributor is an independent company in a new market which purchases goods from the manufacturer and sells them, generally at its own terms. And we all know that companies can offer complete formulas to persons or companies abroad. These types of franchise arrangements are also contractually defined. So these 3 market entry strategies are based on contracts. Now we can go a bit further and we can even consider that a company enters a new market by a takeover. When we hear the word takeover, we think about a competition law, because takeovers might be submitted to rules. And in the European Union, for example, we have a merger regulation which requires large companies to report a potential merger to the European Commission for approval. We move on to the marketing level, and we have here the same principle: objectives and strategy. Marketing's objectives are generally formulated in terms of market share, and the marketing strategy, as already discussed, contains 3 elements: target group, competitive advantage, and positioning. A few remarks about that. Not all groups in society can be target groups. Generally, legal systems prohibit or put limitations on communicating with children or sick people, ill people, patients. We should also realize that a company in its positioning cannot just state what it wants. If you state something which damages a competitor, that competitor may submit in court a claim for compensation, and we will see that the basis thereto is the legal concept of an unlawful act, or as called in common law, a tort action. Unlawful act is the civil law term. Now, if a company thinks that it could defend its market share by making a price agreement with a competitor, that could result in a cartel. And if a company successfully increases its market share, and that market share becomes fairly high, 40 to 50%, then it runs the risk of abusing that high market share, and that could, under competition law, qualify as abuse of a dominant position. If we then go to the marketing mix, the list becomes pretty extensive. We have rules which regulate products, rules with respect to liability, meeting what the customer is allowed to expect based on the contract. We call that conformity. You have rules which dictate what info there should be on the packaging, and you have rules on waste management. Price, the question is, which price info should a company make available to potential buyers? Price could be used in a way that it violates competition law, and we should always take into account in setting prices that most countries in the world have a value-added tax system. Promotion is an incredible broad area of regulation. We will see that advertising is subject to rules on comparative and misleading advertising. In the European Union, we have rules for so-called unfair trade practices. Now, something which generally interests specifically young people at the moment is social media. And presently, we also have regulation of platform selling. And finally, we also look into these platforms in the context of place, distribution, whereby specific interest is in selective distribution agreements. And here again, we bring in the concept of third-party risk management, because in distribution you generally cooperate with other parties. And the question is, do they behave in such a way that they do not impose on you the risk of harming your reputation? And finally, completely at the bottom, which you probably can't see due to the fact that I'm in the right-hand corner, in the bottom corner, is privacy. Now, this all creates a pretty complicated picture. I do think it makes clear that marketing managers are in a difficult position. A substantial amount of regulation, which, because they are managers and not lawyers, is not so easy to identify or to understand. So they will have to resort to lawyers, and lawyers who advise them hopefully understand what marketing is, in order to optimize the manner in which they support what they actually work for in a company, which is the business. In order to understand what the legal consequences of marketing's behavior can be, we first need an understanding of a basic legal concept, and that concept is liability. Simply said, the law can hold you responsible for what you do, in the sense that if you do something which damages another person, that the law may hold you liable for the damage, to compensate the damage you inflict on another person. Now, that liability concept is present at different levels. We have different types of liability resulting from different sources. Now, for the moment, from a civil law perspective, we look at liability risks from the perspective of public law, private law in general, and contracts, which are part of private law, more specifically. First of all, when we talk about tort or unlawful act, we talk about the relationship between private people to which the law attaches the consequence of liability. We call that liability, which has a basis in the law, statutory liability. But that statutory liability is of potentially two types. The law may hold you responsible, liable, for the fact that you are acting in a certain quality, like an employer, like a parent for a child. That strict liability is simply there without you to be blamed for anything or without you making a fault. That brings us to the second type of private law liability, which has a basis in the law, and that is the fault liability. Fault liability means the law holds you liable if you are to blame for what you did. Public law, if we move down, may also lead to liability for a company's acts. That results from the fact that the state has the authority to prosecute you, and as a result of prosecution, a court or another institution may impose a penalty on you. Finally, if you enter into a contract, the contract can contain clauses, and the clauses may define that you or the other party, in case something happens, will bear the liability resulting from it. Now, if we talk about private law and public law, then there is a connection, and that connection is maybe not that easy to understand at this moment. But if we take the unlawful act under Dutch law, then one reason for unlawfulness is that a company breaks the law, violates an article in the law. If that article is, for example, an article of competition law, then the authority which enforces competition law, a competition authority, may impose a penalty on the company. But by setting that penalty, it is established that the company acted against the law. And any acting against the law is unlawful, which means that those people who are damaged by it can invoke private law to claim compensation for the fact that the company violated public law. So this is the link between public law and private law. When we talk about tort, we talk common law. When we talk about unlawful act, wrongful act, we talk civil law, and we'll find a comparable legal concept under Islamic law, which is damana. Basically, they all come down to the same. The law provides an opportunity for legal subjects to be compensated for the damage inflicted on them by other legal subjects. And the general approach is, if there is a certain way of acting which is unacceptable, and there is a clear causal link between that acting and the damage, the law will allow you an opportunity to get the damage compensated. Now, under civil law and common law, you will find specific regulations for product liability. That product liability, as any other liability, is under Islamic law, encapsulated, incorporated in that damana principle. we explore, but it is pretty detailed, we explore a bit how it works under Dutch law. Dutch law defines the wrongful, unlawful, tortious act, and in the definition it includes 4 requirements, and the 5th requirement is in this article 163. I will leave out that 5th requirement for reasons of simplicity. The 4 requirements are somebody must have acted unlawful, that unlawful acting must be attributed to him, there should be damage, and the damage should be the result of the unlawful acting. And now comes the big trick or big difficulty. The first requirement is unlawful acting. That is possible in 3 ways. The first is violating another person's right is unlawful. So if you violate a copyright or a patent, that is unlawful based on the unlawful act. If that leads to damage, compensation can be claimed. When a company or you act in violation of a duty imposed by law, we just discussed competition law, that also can qualify as unlawful and justify a claim for compensation. And the third one is extremely broad. What according to unwritten law has to be regarded as proper social conduct. Basically this comes down to that any behavior which may qualify as improper social conduct, so conduct which in our society is not tolerated, that may also qualify as unlawful and therefore may simply provide a basis for compensation. Then the second requirement, this attributability, that's quite a difficult word, is further explained in paragraph 3 of this highly relevant article. And it says a tortious act can be attributed if it results from his fault, so there should be blame, or if it's not a case of blame, when the law considers him to be responsible for that behavior, or when we can derive from generally accepted principles that the behavior is to be considered as unlawful. The 5th requirement I'll leave for the moment because it usually leads to extensive discussions which usually do not clarify the unlawful act. Now, what is the situation in the Netherlands? We have this unlawful act article. We have discussed 4 requirements. There are 5. And when all 5 are met, the damaged party is entitled to claim, to be awarded, after he claims, a remedy. Now, what is now the relevance of these claims? The relevance of these claims is that they can be demanded, asked for in court by consumers and this is of course particularly important for a business, also by competitors. Now if you go to table 9.2, we answer the question, what can you get? What can you ask when you are damaged by unlawful behavior of another party? Well, we mentioned it a couple of times already. You may claim financial compensation for the damage. But if somebody writes something about you which is not true, you may ask the court to impose an obligation to rectify what the other party published. You may also ask the court to stop the other party from continuing his behavior. For example, an advertising is damaging for your product. You ask the court, impose on the other party an obligation to stop the advertising. And finally, you may also submit behavior of another party to the judgment of a court and ask the court to take a decision on whether it's acceptable or whether it's not acceptable in the sense that it is unlawful. That could already be sufficient to stop the other from continuing, and if the court declares it unlawful, it does provide you with the basis, if necessary, for claiming compensation. So, here we see one of the marketing managers in the EMEA region. And we've now looked into the basics, and it's time to provide an overview which illustrates to you what type of regulations influence the daily work of the marketing manager. In the beginning, we emphasized both compliance and legal, specifically with these 4Ps. I hope you remember, moving outside of the company. It is of key importance to make sure that the company is not damaged in its reputation or subject to claims due to the fact that the marketing mix is, or its elements are, not compliant. Compliance we also split up in internal and external. Internal, as a marketing manager, you're subject to the company's code of conduct, any policies the company may have, and many international companies of course have, with respect to corporate social responsibility and anti-bribery, and that is a typical element we bring in with respect to marketing. Because marketing moves outside of the company, it is generally subject to strict approval procedures, whereby in the end a lawyer internally or sometimes externally should sign off the marketing materials for compliance before they can move out of the company. Externally, there are some typical legal issues for compliance. The advertising, is it not misleading? And if it's comparative, is it within the acceptable boundaries of the law? Within the EU, we have the concept of unfair commercial practices. Within the EU, we have very strict privacy regulation, and generally advertising, or more broadly marketing communications, are subject to industry self-regulation. Externally, because we are communicating with images and text and pictures and maybe sounds, we may violate unknowingly other companies' IP rights, which, as we now know, could constitute an unlawful act and result in having to pay compensation. Competitors may be damaged by our unlawful behavior, like a statement in an advertisement which is not true. When the product, the P of product, does not do what we promised the consumer, we call it non-conformity, and that may have consequences. Supervisory authorities exist outside of the company who scrutinize the company's behavior. And there are a couple of risks which are specifically related to the company's reputation. Privacy should be respected. Violations easily lead to negative press coverage. Hurting, damaging people by a product which is defective is also a source of reputational risk. Bringing products on the market and then having to call them back because something is wrong also involves a reputational risk. And finally, we do not like to get in the press with penalties or even our names and our behavior described by a supervisory authority in a public document. So this is the risk area, the general risk area for a marketing manager, a list of the regulatory dimensions of marketing with an emphasis of marketing communication, and that is what we will be using to structure the rest of this lecture. Where does this nightmare result from? First of all, when we focus on the European Union, we know that law as a starting point is national, but that in the context of consumer protection, which is considered a key element of the European Union, the EU has extensively regulated commerce. I'm not using the word marketing because the EU directives not always use the word marketing, but collectively apply to what from a business perspective is considered marketing. Now there are EU directives on misleading advertising, comparative advertising, rights for consumers, e-commerce, and very recently one on audiovisual media services. Next to that, we have our own Dutch civil law or any other national law which applies. In general, you will find in all jurisdictions codes, self-regulation, which specifically regulate advertising and all those areas which come close to advertising. Now, what do we find? A bit, I must say, from the perspective of Dutch law and EU law, we find the following. In business-to-business compensation, communications can be misleading. If that is the case and another party is damaged by it, it provides a basis for a claim for compensation. Misleading business-to-consumer advertising or communications are considered an unfair trade practice, so they allow a consumer to nullify a contract, to annul it, to have it declared void, and it allows, in case there is damage, a claim for compensation. Comparative advertising is allowed within the European Union, however, under certain conditions like objectivity, the products must satisfy the same need, etc. Then with respect to websites, it is often thought that websites are something special, but that is not the case. All rules which apply to advertising apply identically to advertising on websites. On top of that, websites are considered services of the information society, which means that they impose an obligation to put certain information like name of the company, chamber of commerce, VAT number, etc. on the website. And then if you as a company sell via a website, the rules on distance contracting and the rules on distance sales equally apply. Social media, generally considered rather interesting at the moment, it's the same story. Everything which is advertising on social media means that it is subject to all rules on advertising. And generally, and we also see that in the Netherlands, you have a special social media code. The Dutch Advertising Authority has developed an advertising code, a code of practice for advertising, and a sub of that, a specific part of that, is constituted by a social media code. Now, social media codes and legislation require a vlogger or an influencer which vlogs for you to disclose the nature of the relationship with the sponsoring company and to reveal by which company the vlogger, the influencer, is sponsored in his communication to customers and potential customers. Whenever a commercial practice, and that is in itself, in its wording, broader than marketing, but it does cover marketing, is misleading or aggressive, and it qualifies as an unfair trade practices, then that is prohibited under the law. And we have recently seen that the European Union also tries to regulate platforms. And it distinguishes two types of platforms. Platforms on which companies sell to consumers and platforms by which companies by themselves sell to consumers. Well, generally speaking, you can say that those type of platforms, when they make use of a ranking, they must be transparent on how the ranking came into existence. So they must reveal the criteria and, if so, whether payments were made for the ranking. There is even a blacklist of unfair trade practices, which you can see on the next slide. And as a last note, if you employ salespeople who sell on behalf of you to potential customers, then they talk to them by phone or otherwise in person. That may generate expectations, and expectations are to be met. And if those expectations are different from what you as a company would like to see communicated as expectations, you cannot hide yourself behind that, because communications by salespeople are considered to be part of what is communicated to the market on a product. And if they trigger expectations and those expectations are not met, that results in non-conformity, not meeting what the customer can expect based on the contract. And that of course has consequences like annulment of the contract, or in case of damage, compensation for the damages. Here you find this blacklist of commercial practices. This simply is the list of things which a company never should do, because the law qualifies them as a commercial practice, and certain commercial practices as listed here are simply not allowed. Now, if we go to the product and we consider that from a regulation perspective, we know that we have Dutch civil law, but we also saw that a lot of regulation has its basis in European Union directives. And the peculiar thing is that these European Union directives are transposed both in Dutch law, but also in the Dutch advertising code. Now, when we talk about this salesperson in the previous slide, we use the word conformity. It might not have been perfectly clear at that point, but now when we come to product, we can simply say a product should do what the customer can expect it to do. Now, that is the way the law looks at a product. It uses the concept conformity, and when a product does not do what a consumer can expect of it, this constitutes non-conformity, and this non-conformity is a breach of contract, with all the remedies for breach of contract becoming available. When we talk about services, the breach of contract is that a services provider does not perform properly. And when is a service provider not performing properly? When the services he provides lacks the care of a good services provider. This is very general, of course, but it comes close to the expectation approach with respect to sale of goods. You can expect a services provider to act in a professional manner, and if he doesn't, it can constitute a breach of a services contract. Now, under Dutch law, as a result of a regulation, consumers who order at a distance, or consumers who buy not in the shop but off-premise, have a very strong right. They can withdraw from the contract in a period of 14 days after the contract was concluded. When a product is defective, meaning in legal terms not providing the safety which one can expect from the product, it constitutes a strict so-called product liability on the manufacturer, which allows those damaged to claim compensation for the damage. And finally, we have some packaging, waste and recall rules with which a company should also be compliant. I cannot go into all of the details. First of all, they're too complicated. And secondly, due to that, it would take too long. So a lot of the 4P links to regulation are pinpointed in order to create awareness and in order to provide a basis for discussing with a company lawyer what potential non-compliance may result from the fact that you are bringing the 4Ps on the market. Price, also pinpointing. Generally, in countries you have specific price control acts which a government may use when there is a war or another disaster in which they want to keep, for example, the bread prices low. In certain markets, like in medicine, we'll find specific policies for calculating the ultimate market price, which will be reimbursed to a manufacturer of a medicine. In business to business, we must take into account that when we deliver goods to our own company, as generally that will be a separate entity to which we sell commodities or half-made products or complete products, that these intra-company deliveries are subject to tax rules, and that the tax authorities, because you may reduce your profit with it in a certain jurisdiction, that the tax authority may not accept your price but impose a different price on you, which results in a slightly artificial profit, which is subsequently then taxed by the tax authorities under that national corporate tax regime. With respect to business to consumer, EU directives have imposed on companies a number of price information objectives, which come down to create absolute clarity, include VAT, include all potential costs, and you are not allowed to change prices after a consumer has ordered without specific consent. And then finally, as already previously discussed, pricing may violate competition law by price agreements leading to a cartel, or by imposing prices or conditions which are based on the fact that you have a very strong position in the market and therefore can more or less impose it on other companies in the market, because your position is so strong that those other companies have no opportunity to deny it. They are more or less by your strong position to accept it, so it comes close to what we could call blackmail, and that type of blackmail is in legal terms, within the context of competition law, labeled as abuse of a dominant position. Now, place or distribution is the fourth P, but from a business perspective, distribution is a bit old-fashioned. The business now talks about supply chain, and supply chain is broader than distribution. It involves all parties involved in creating and bringing the product to the market. So it involves suppliers, resellers, buyers, and nowadays also platforms. The fashionable term is now responsible supply chain management, the adoption of the corporate social responsibility concept within the setting of a supply chain. So a company has the opportunity to make a supply chain more responsible by contractual clauses with its suppliers, for example, and of course by third-party due diligence, not making use of any other supplier before having checked that supplier on its behavior, and if that behavior does not create any risk for the reputation of the company, the supplier can be contracted. And another tool which companies use to create a responsible supply chain is to develop specific supplier codes, for which a supplier, if he wants to become a supplier, has to sign. A difficult topic is selective distribution. You have a product which is a luxurious product and you do not want it to be sold in each and every shop outlet. You only want it to be sold in outlets which fit in the whole luxurious image you want to create about your product. So your strategic choice is to go for selective distribution. You're going to make a choice which outlets you will allow to sell your product. That in itself can lead to a situation which conflicts with competition law, because you actually distort the market. Is it then completely prohibited? No, under certain circumstances is allowed. If the nature of your product provides a reason to do so, and you apply objective criteria in your selection process, and your selection criteria do not go any further than what is necessary to create a selective distribution network that fits with your product, then it is allowed. But is then everything allowed? No. You can include in the contract a clause which prohibits the chosen distributor to sell outside of the territory you agreed upon. But what you cannot prohibit, because that conflicts with EU competition law, is that when a selective distributor is approached by a customer from outside of his territory, that he does not meet that order. In other words, we call that passive sales. Passive sales you cannot prohibit. Now you may think we can use geo-blocking. Well, geo-blocking is also not allowed under EU law. What is allowed is regulated in a specific so-called vertical block exemption regulation. And that vertical block exemption regulation, for example, also excludes two parties which together have a very small market share, like a 30% market share, to be subject to the rules of competition law. In other words, the vertical block, as it says, exemption regulation indicates under which situations the prohibitions of competition law for selective distribution do not apply. Well, as said, we're pinpointing. We can go into extreme in the details, but that is, as said, something we are not going to do. Now, finally, many of you will be interested in websites, in selling with websites or providing services with websites. Websites are extensively regulated and the rules come from various sources. Fortunately, we live in an internet age in which you can find very useful information for free on the internet. Now, the Dutch Authority for Consumers and Markets has compiled a checklist for website and social media sales. So if you're considering to sell via a website, or if you already have one and you want to check to which extent you are compliant, I happily refer you to this list. In the very beginning, we discussed the extensive regulation of marketing, and we stated that this is due to the fact also that marketing interacts with consumers. Now, this interaction results in data. The data which consumers make available to companies by reacting to advertisement, by completing forms which result from direct marketing, by making a phone call to a company, by visiting a website. All these data might be used by a company in a way which the European Union considers unacceptable. The European Union protects consumers, people's privacy. The document which does it, you see stated on top, is the GDPR. The GDPR is the abbreviation of the General Data Protection Regulation, which extensively protects consumers against the use of data on them and which assigns rights to those consumers. Now, both mean that the use of personal data by companies is limited. Now, is it because it is an EU regulation only applicable to companies in the EU? No, the regulation says it applies also to companies outside of the EU, which are involved in collecting, using data of EU subjects. What type of data are we talking about? Two types of data: the personal data we already mentioned and a specific category called sensitive data. The latter involves highly personal information, for example, on health, and genetic data are also part of the sensitive data. These data are even more extensively protected than the regular personal data. Anything which can lead anybody to a specific person is a personal data, like name, address, but also an IP address, a cookie, or whatever. It are all personal data. Now, in order to understand the GDPR, we need to understand four basic concepts. We have the data subject, that is the human being on which personal data are available and make use of. We have the company who finds data, collects data, stores data, processes data. That's the data controller. But the data controller may assign these activities to an external party, which then becomes the data processor, or the person may make his data available by himself on, for example, Google or Facebook, whereby Google or Facebook then become the data processor. And in each and every EU member state, there is a data authority, a supervisory authority, which checks whether companies do not violate data protection rules. The GDPR imposes a set of obligations on companies which are involved in doing something with personal data. This doing something is very broadly defined as processing. So anything you do with data of a human being is referred to as processing. So this term is used to impose obligations on company. Now these obligations, you see them all here, come down to the obligation that if you collect data, you do it for a certain purpose, and if you have that purpose, you should not collect more data than is necessary for that purpose. So a direct mail, you only need a name and an address, or you can say, if you segment the market, some more information which you need to segment the market. But you should also make sure, of course, that those data are correct, and that is what you see prior to the last one. This what is called in the GDPR storage limitation. So you must have a system in the company which states for each and every data set how long you plan to store it. That time frame must be acceptable within the GDPR setting, and once the deadline, or the ultimate date I should better say, is reached, you must trash it, you must destroy the information. And the system you store the information in and the system you use for processing, it should be secure in the sense that it cannot lead to leaks. Now you may say, what does that mean for me as a company? What it means is that you must interpret these general obligations, which are a bit wide, with respect to your own situation, and make sure that you as a company within your own situation meet these processing requirements. You must also have a system in place which allows the data subjects to exercise the rights the GDPR gave them. So you must give a contact point by which they are able to realize those rights. For example, and this is of course the most important one, they can request you to have their personal data erased from your system. We call that the right to be forgotten. They may want to take the data you have to another company. We call that data portability. In terms of the GDPR, it would mean transmitting your data to another controller. And if you use data to profile customers, potential customers, you must give the data subjects the right to object that. Why can they object it? Because they could request information on what you are doing with their data. And if you inform them that you use those data for profiling, they of course can take the next step of prohibiting it, or at least to object to it. Why is the GDPR such a hot issue? Because the fines which the supervisory authorities, and we saw you have a national data protection authority in each EU member state, these can impose substantial fines on companies for data breaches. If a data breach occurs, so let's say if data are leaked, you must immediately inform the data protection authority on it. And if you breach, if you violate GDPR rules, you may face a fine, and the fine may run up to 20 million euro, or even, if that is a higher amount, 4% of your global turnover. So from a financial perspective, the GDPR is a high risk area. That means that you must manage it properly. To finalize an overall picture of these elements, this is what you must realize in a company, and this is a system which you as a company must build. The GDPR does not tell you exactly what to do. The GDPR gives you the end result. The GDPR tells you what data subjects are entitled to, and then it is up to you as a company to build a system which meets the requirements of the GDPR. Now here we are towards the end, and we started with saying compliance for marketing is a nightmare. At that moment in time, it was not yet perfectly clear what that nightmare consisted of, but we have now been running through the 4 Ps and their links with regulation. We have been running through the GDPR requirements, and finally what we should do is have a look at competition. So here we are at the area, the branch of competition law. From an economics perspective, maybe I should say from a business perspective, a race to be the winner, a race for market share, a race to be the first on the market, because that generally is a better position than the companies who follow. But competition law, as we said, protects consumers, because legislators, the EU including, know that companies have power and that they can make agreements or otherwise reduce the competition, and that is not in the interest of consumers, because the interest of consumers is that competition exists and that competition drives down prices and stimulates innovation. That is in the interest of consumers and ultimately, as such, in the interest of society. Now, competition law is having two dimensions. What you see at the top was just discussed, but we should realize that competition law has a public law dimension and has a private law dimension. We have discussed this difference already in the context of liability risk, but now hopefully the link between public and private law and compensation becomes more clear. First of all, the public law dimension is in the Treaty on the Function of the European Union, specifically in these two articles, and the articles are almost identically formulated in the Dutch Competition Act in the articles 6 and 24. What does competition law prohibit? Cartels. And when we mentioned it, we talked about agreements about prices between companies, but we add another concept to it now, and that is the concerted practice. Competition law also prohibits behavior of companies which is not the result of a formal agreement, but which results from being into contact with each other, and that contact leads to a behavior which results in a cartel. You must think about directors of companies meeting each other regularly, and although not explicitly agreed upon, they keep their prices high and they avoid price competition. The second is this abuse of a dominant position, a very high market share, enabling the company with a very high market share to impose prices or conditions on other participants in the market. Now, the public law risk is prosecution by a supervisory authority and the resulting penalties. That public law risk results from the enforcement right, which in the EU has the Commission and which in the Netherlands has the authority Consumer and Markets. Courts come in play when companies want to appeal from decisions by the Commission or the Dutch Competition Authority, which is part of the ACM. These enforcement authorities have specific tools to enforce competition law. They may all of a sudden come into a company. We refer to that as a dawn raid, early in the morning. They have the authority to seize documents, including emails, and when they find that competition law is breached, they can impose penalties, and they can publish about their finding what we call naming and shading. The penalties in the EU are fairly high. They can go up to 10% of the revenues, and within the setting of the Netherlands, they can go up to €900,000 or 1% of the turnover. And when the breaches are very serious or recurring, they may go up to 10% of turnover. Now, you are not always penalized as a company. It may be possible to come to an agreement, and we can call that a commitment agreement, in which you state that you will restore your behavior to normal, that you will stop your behavior that violates competition law, and then you may qualify for a leniency, meaning that a penalty will not be imposed upon you. If there is a cartel and one company reports it to the European Commission or to the ACM, it may also qualify for leniency in the sense that the European Commission or the ACM will not impose a penalty on that one company which reported on the cartel. Now, the private law dimension is that violating competition law is within the definition of what is unlawful, a violation of a statutory duty. Now, a company, a consumer, or a group of consumers may start a litigation process if they can evidence that they were damaged by the violation of the public law competition rules. They may be successful in claiming a compensation from the violating company in court because violating competition law is unlawful. You will find here some examples of extremely high cartel fines imposed on a number of companies. In a cartel, companies cooperate in keeping generally prices high. You will find it split out per undertaking. We just saw this truck cartel, and in that truck cartel, Daimler, Scania and DAF cooperated, and all of them received a specific cartel fine. The biggest fines for abuse of dominant position are listed in this overview, but fairly recently Google, and we will see that name frequently in the context of competition law violations within the EU. Fairly recently, Google was fined 4.3 billion for abusing its dominant position in 3 different markets: internet search services, licensing smart mobility solutions, and app stores for the Android mobile OS. Well, you know, most lawyers are not very technical, and I'm one of them, so I'll leave it up to you to go to this site and see what exactly was the case. And now we can finalize, we can integrate from a strategic management perspective, and we come back to where we started. We took, I should better say, marketing strategy, and we took the marketing mix. We took on the vertical side what can happen outside of a company, and we create a framework which we can use to identify what of the developments we see externally have a potential impact on our strategy or on our, as the next slide will show, marketing mix. So that was it for the moment, ladies and gentlemen. It is never completely satisfying to talk about marketing and regulation in a short time frame, because it requires us to focus and it makes it impossible for us to discuss all the details. Now, keep in mind that many a lawyer will not know all the details. So your situation in a business is to stimulate the legal department to look at the outside external regulatory environment from a marketing perspective. Now, marketing is a specialized discipline with its own concepts, and the challenge for you as a marketeer is to identify what's going on and then, with the help of a lawyer, create a situation in which the company is compliant. Let's say that's the shared responsibility of legal and marketing, and that shared responsibility is an enormous challenge. Good luck with it in practice, but keep in mind, stay on the safe side, be sure you comply with all that regulates your